Sardar Ishaq Khan Sahib, as you know, is a judge of the Islamabad High Court. He was elevated to the bench in December 2021. Before that, he was a senior partner at a firm in Islamabad where he led a broad spectrum of practice areas in commercial litigation, regulatory, and corporate transactional work. He negotiated and concluded transactional contracts for several infrastructure projects in Pakistan and abroad for national and international clients. He is a barrister of Lincoln's Inn and an alumnus of the universities of Punjab and that other place, which I won't mention, Oxford, because I'm from the other place. Let me also then call upon Dr. Rahim Awan. I mentioned Dr. Saab to you already, and I quoted from his works on bilateral international treaties. Dr. Awan is currently Director General Legal Aid and Justice Authority, Ministry of Human Rights. Having 20 years of diverse experience outside and within Pakistan, he has worked as Secretary Law and Justice Commission of Pakistan, as well as Secretary of the National Judicial Policy Making Committee. He also worked as Secretary Governing Body Access to Justice Development Fund. He remains Secretary Provincial Justice Committees of all 4 provinces and the Federal Capital, and as Secretary National Judicial Automation Committee, as Secretary of the Police Reforms Committee, and as the focal person nominated by the Honorable Chief Justice of Pakistan for European Union program called TIEX. Very happy that Dr. Awan could join us. And I will also call upon Dr. Qureshi Khan to please also join us. Dr. Khan is a civil servant and a member of the Police Service of Pakistan, PSP. With 18 years of experience, he is currently the Assistant Inspector General of Police, training at Central Police Peshawar. During his career, he served on field staff and strategic level assignments. Previously, he worked as an Additional Secretary Law and Order at the Home and Tribunal Affairs Department of Peshawar. He also worked as a National Policing Specialist at UNDP, Pakistan, for 4 years. He has been awarded a Distinguished Service Award for establishing an Institute of Forensic Science in Peshawar. Thank you very much, Qureshi Saab, for joining us. This session really explores ADR in Pakistan and the need for reforming it further. So without much ado, may I call on Justice Sardar Ejaz Ishaq Khan Sahib to give his remarks. Thank you, sir. Please, big hand.
Bismillah ar-Rahman ar-Rahim. I put a brief presentation together, and I can understand that all of you have been listening all along, so I'll go through it very quickly. I have 15 minutes allotted to me, so I tried to wrap it up in about 5 to 7 minutes, and then I'll take any questions if you wish to. First of all, my comment to Nudrat, if she's around, why have you put a question mark there? You know, there is absolutely no doubt that ADR is the way forward. We are already lagging behind, there is no doubt. You asked for a judge's perspective, and since you've asked it, I'll give it to you. I must clarify that this is entirely my perspective, although I add that I can say it with confidence that to the extent of support for ADR, I speak for all the honorable judges in the High Court. The topic that was given to me is so vast that it practically covers everything. So what I've done is I've tried to put together my thoughts from a perspective point of view, and I hope some of these will touch on these topics. So next slide, please. My perspective is that it is our religious duty, and as you heard earlier speakers also talk about it, Qari Saab read that ayat from Surah Nisa, which is primarily about disputes between families, but also between two warring tribes. And from Surah Hujarat, the ayat is Bismillah ar-Rahman ar-Rahim. Innamal mu'minuna ikhwatun fa aslihu bayna akhawaykum wattaqullaha la'allakum turhamun. So all believers are but brethren, so make peace between your two brethren. This is a direct command to us. And remain conscious of God, and it is connected with taqwa, so that you might be graced with His mercy. So Allah is connecting, granting His mercy with this command. And then there is the hadith from Tirmizi and Abu Dawud, when Prophet ﷺ said, should not I tell you such a practice which is higher in rank than fasting, charity, and prayer? And when asked, he said, make sulh, amicable settlement between two opponents. So this is not just something that is, you hear from foreign jurisdictions being imported as ADR in our country. No, this is our religious heritage. Next slide, please. I would say that I put it together. I am a certified mediator myself, and I have had a lot of discussions, formal and informal, and it always comes across to me that there are certain fallacies of thought which, again, entirely my perspective, need to be addressed for this ADR culture to take root. I have, like the 7 sins, picked up 7 fallacies, but there are certainly more. Next slide, please. I think they have some problems. So one that is not added there, and I'll take this time to speak about that, is even today you've heard, there seems to be an overwhelming importance attached to the concept of reducing the burden of the courts. That, to me, is an ancillary benefit of ADR. And this may come as a surprise to you, but it is an extreme arrogance of thought to think that a judge who always has a much narrower perspective of the dispute before him, from the pleadings and from what the lawyers and the parties tell them, that he is, when he gives a decision, he is doing justice. To me, the best justice is what the parties themselves find is best for them. And this thinking fallacy, because as was pointed out by Hamid Saab, that in litigation and in arbitration, there are winners and losers. There is always one who wins and one who loses. And it is always debatable by the losing side whether it has been meted out justice. Hence the appeals. But mediation, and that is the ADR method that, if you study globally, is the fastest developing one in the last 2 to 3 decades, and has the greatest uptake worldwide. There is no decision in mediation. The mediator doesn't give a decision, but a mediator is a trained person to bring the parties to a settlement which they choose to accept, because when they weigh the pros and cons of a long-drawn contest in the court, which except in the most few of cases, is inherently unpredictable. And the parties are in control. And the second fallacy, before I go on to this one, is that somehow this will take work away from the lawyers. Unfortunately, the legal culture in our country, the legal industry in our country has predominantly developed in a way where a lawyer gets remunerated once he steps into the court, once he files the case. Not saying much about that, but in mediations, the lawyers are as much a part of it. And from the senior lawyers sitting here, there's perhaps a few things more painful than finding a case that you took the fees for 10 years ago, and you have to prepare it because the case is fixed day after tomorrow, and you have to go and argue the case. Whereas in mediation, you can be over and done with it in 30 days, and the lawyer gets remunerated. So worldwide, If you study, all the legal law firms, all the law firms now have mediation lawyers, not just arbitration lawyers. And it is a fact now that there was I was at a call with a mediator in the US, and he said that now we get calls from Silicon Valley, who are the highest paying litigators, if you like, who now are ready to pay the same dollars per hour, but they don't ask for litigators first. They first ask for, give us your best mediation lawyers. So it does not take away work from the lawyers. It only shifts that work from the courtroom to a mediation setting. So I would come to the fallacies, 7 fallacies that I've chosen for this quick presentation of thought. The first one is that the same ecosystem will suffice for all kinds of ADR. And this, as I said, it's my perspective, so you please forgive me if any of you find these views a bit extreme. But ADR will not develop because once you put a brick and mortar with some staff sitting there. It needs the ecosystem. And by ecosystem, I mean trained mediators. And what you have heard this morning, a mindset of the entire community connected with the legal system, that ADR is a good thing. And the sub-fallacy of this is that only judges and lawyers will make good mediators. Not at all. Worldwide mediators are architects, engineers, and they understand there's lingo and the jargon and the speciality of their specific industry. And when the mediators are chosen, if it's a construction dispute, they would ask for a mediator who is himself an engineer. And they are far more effective mediators than lawyers. And having judicial or legal experience suffices for mediation. This is again a sub-fallacy of that, and that no special training is needed. And we always hear that we have a tradition of panchayat and jirga system, so we know what ADR is, but we also, the time from which it belongs, they used to use bull plows, right? They don't use bull plows anymore, they use tractors. Because, and just like that, once you get to know mediation, especially a bit more, it is a very specialized skill, I would not say. So what's my perspective on then? My perspective on this fallacy is that ADR outcomes will be readily enforced with judicial conference in the ADR ecosystem. Once the judges understand and have confidence that there are trained mediators, they are being properly regulated, there are ethical issues involved in mediation, which at another time we'll go into that it is functioning, the ecosystem is functioning and in place, they would be far more proactive in referring the cases for mediation. Next fallacy, the second one is the patriarchal fallacy. That is that the government must be the all-encompassing regulator of, and I'm talking about mediation especially here, and that entire ADR ecosystem must be regulated. And that regulation of the ADR market by making rules alone will succeed. Entry, licensing, and oversight of ADR centers and neutrals must be at the ministerial level prescribed by rules. This is what 2017 Act talks about. My question is, why? Nowhere in the world the ADR system has developed because of a direct oversight by the Department of Justice itself. Does the Ministry of Law and Justice have the required capacity to regulate a nationwide, or at least in Islamabad, and not just regulate it, but stay in lockstep with the developments that take place? In the Act, for instance, the government setting the fee for the neutrals. The government doesn't set the fee for lawyers. it doesn't set the fee for many other professions. Why has it chosen in this act to set the fee for mediators? In any serious dispute, the level of fee that is there in the rules is minuscule. No mediator who is willing to spend 30 days for that mediation is going to accept that level of fee. With all due respect, the framers of this legislation have put the government into a difficult position where if they were to raise the prices, the fee for mediators, they will have to give a political justification for that, instead of a market justification, I think this patriarchal fallacy is one of the areas of this legislation that needs to be revisited amongst some others. So my perspective on this is that I would like to see, on a lighter note, the standing committees papers and the parliamentary debates which took place when these policy choices were taken. Next one, please. Then there are statutory fallacies in this. That user-centric design is not material. I give you the example of United Kingdom, which has been one of the countries which has led this mediation revolution amongst a few others. There was absolutely no, it was user-centric. The design wasn't imposed by legislation. For instance, and forgive me for this, I have no idea whoever drafted this, what were they thinking? They said no mediation if it involves intricate questions of law and fact. Well, that is exactly where you need mediation. Where there are very intricate questions of fact and law involved, the case is evenly poised, the risks of an unfavorable outcome are higher, and therefore the incentive for parties to mediate. We must not forget, at the end, a dispute is a dispute. Parties don't come to court or any forum to get, good judgments that analyze the law. They don't worry about it. They want a resolution of their dispute. A commercial dispute about a house, purchase and sale of a house, the parties are not concerned with what the law says or not. Just the law, the judges, the lawyer tells them, you can't do this because the law stops you. So, intricate questions of law, if I would change the first thing, it would be in the act, it would be this. That neutral shall dispose of the matter in 45 days, an arbitrator in 90 days. Why? Why was there any need to impose these time frames? If there is more detail to this, but we leave that for a side unless anyone has any specific questions. Then the act also says that the rules of other bodies will also apply. There is a potential for a conflict of the rules of different trade bodies. And the supervisory jurisdiction, the act talks about that mediation can also be ordered in appellate and revisional proceedings, whereas the bulk of the cases that come before us, especially between the government and government or the statutory bodies, is constitutional jurisdiction, and that stands excluded. Again, from a judge's perspective, I would like to see what the standing committee and the parliament were thinking when they made these policy choices. The next one, please. The Silos Fallacy. And this is a fallacy that needs to be addressed, that it can be done without permanent partners. The education system in the universities, we can't make this successful without them being on board. Professional, commerce, and other regulatory bodies. If you open up Russell, for instance, on arbitration and other books, you will find that there are references to rules or arbitrations by all trade associations and all trade bodies, professional bodies. Arbitration and ADR will not be successful unless the commerce or the regulatory bodies, local governments, have a buy-in. So the design of the ADR system must include them. It cannot succeed without them being on board as permanent participants. And obviously, my perspective is that you can't do it without the High Court, Islamabad High Court either. Unless the Islam, and I'm very glad, I've been here for not a very long time, and I must say that there has been an extremely positive and encouraging reception by the High Court, as you've heard the Honorable Chief Justice and Justice Hassan say about this. So we are on board. Next one, please. Next slide, please. The costs fallacy. This is another question that is often heard, that ADR will increase the costs for the end user. But this fallacy rests on sub-fallacies that a conflict must produce a litigant. No, it shouldn't. It doesn't have to produce a litigant before the court. And the question that is raised is that if it fails, then you have to go to the court, to do dafa fee pay karenge. And so the fallacy underlying is that all ADR referrals will fail. This is a fallacy. And that's why organizations like ICADRP are a need of the hour, because they would, apart from providing the dispute resolution facilities, also carry out the R&D that is required for collecting data and stats on this. So a judge's perspective on this is that I hope that the year-end statistics that will come for us to read will show the settled percentage to be higher than return to the court percentage of the cases that have been referred for ADR. Next slide, please. Arbitration law reform, because it was on the topics given to me, so I had to include it. I will not say anything about the international arbitration here. We are yet an insignificant player on the global arena, so I can't say much about that. But domestic, please, I'll talk about domestic. And another fallacy is that the Arbitration Act is flawed by itself. Like any other legislation, it has its shortcomings, but it is a workable one if it is to be worked. And I give you an example, or I'll come to that. Then another fallacy is that for arbitration to be mainstream, arbitration awards must be immune to judicial scrutiny. And that, yes, this is the major fallacy, that ad hoc arbitrations alone can imbibe an arbitration culture. Nowhere in the world where arbitration has been successful, it has been successful without institutional arbitration. You know, the honorable members of the district judiciary sitting here would all know that when they refer a matter under Section 20 to arbitration, they ask the parties to give names of the arbitrators and randomly pick it. And almost half of the cases that come to the courts, at the High Court, are a result of a mismanagement arbitration process. So the flaw is how an ad hoc arbitrator, an untrained arbitrator, arbitration is a skill. It needs, just like all you lawyers sitting here have gone through an educational system, training program, it is a skill. The process management in arbitration is a skill itself. And ad hoc arbitrations cannot deliver that. That's why organizations and bodies like ICADRP are a need of the hour, because they manage the process while the arbitrator focuses on resolving the dispute. And my perspective is, why should judicial time be spent to rephrase instances of mismanagement of arbitral process as legal questions? I'll give you one example. I don't know if any counsels are sitting there, but an arbitration which took 2 years, and I'm sure millions of rupees and man hours, professional hours to conclude, has now been in the High Court for the last several years on a simple question where the arbitrator handed over the arbitration award by hand to one of the parties, and the entire dispute is on the question whether it was served in time or not. So it's a mismanagement. It would not have happened if it were an institutional arbitration. Next slide, please. The panacea fallacy. That ADR is the panacea to all our ills. This is obviously ills of the judicial system. Obviously, it's a fallacy. Conflict, because ICADRP has used the word conflict in their presentations and all. It is all about a conflict between two parties or two or more parties. And the courts come at the time of resolution and enforcement, the last two stages, whereas the prevention and management is as much a part of conflict management in a society, which requires attention. And any ADR processes enable the parties that prevent the dispute from going to stage number 3 and 4 by judicial tribunals. So a bit of philosophy here, if I may be allowed to say so, is a polity's evolution involves how a society chooses or uses the tools to resolve the disputes among its members. This is the third wave strategy. If I may use a loose analogy here, it is the latest technology, mediation. You know, you have models of iPhone 5, 6, 7, 8, 12, 13. So this is the third wave. Any one of you who have read Alvin Toffler's Third Wave book would understand what I'm saying. This is the third wave, which is a conscious recognition by the executive and the judiciary to deploy the adjunct tools to litigation for conflict resolution. So ADR is the toolkit, you know, and its tools are mediation, arbitration, neutral evaluation, conciliation, med, and more tools will come. And it is a fact that there is a rising global usage of these tools for dispute resolution. And my perspective on this is that why are these tools still in short supply in Pakistan to a judiciary which is creaking under caseload? It's a question that we don't know. There's no answer, but we can all wonder why have we still not deployed these tools for dealing with these with the caseload. So I think that was the last one. So I've gone through this very quickly. I don't know how much time I have, sir, to take any questions. I need to wind up. So I'm sorry I can't take your questions. You know. So on that one, thank you.
Thank you very much, Justice Khan. We're running a bit late on time, so I'm going to request our next panelist to really be brief so we can have a bit of a Q&A session before I call on the minister who has arrived.